President Obama embarrasses himself and sullies the office of the presidency with a shameless attack on the United States Supreme Court. I'm Matt Barber, Vice President of Liberty Counsel Action. Joining me again in studio today is Shawn Akers, Vice President of Middle Eastern Affairs for Liberty Counsel. Shawn, President Obama, again, has created a situation where he has been verbally reprimanded, scolded publicly by a number of conservative pundits, certainly, and a number of congressmen and senators for this attack, really, on the United States Supreme Court, targeted clearly at the conservative justices there on the court, suggesting that it would be, quote, unprecedented and extraordinary for the Supreme Court to rule that his Obamacare monstrosity, this unprecedented, you want to talk about unprecedented, attempt to compel, for the first time in history, every American to enter the stream of commerce and affirmatively purchase a good or service required and approved by the government, the federal government. He has said that it would somehow be unprecedented and extraordinary if the United States Supreme Court were to overturn, which is what they are supposed to do, this unconstitutional law. And my understanding is that President Obama, at one point in time at least, allegedly taught constitutional law. What is he thinking?
You know, Matt, I don't think he is thinking. I think what he's doing is strategizing. Welcome to Chicago. Yeah. What you're looking at, President Obama, I wish, had taken some notes on presidential decorum from even some of the great Democrats of the past, because to stand up and scold people constantly, whether you're scolding senators and congressmen at the State of the Union, or you're scolding the United States Supreme Court at the State of the Union, or now you're publicly scolding the men and women that sit on the United States Supreme Court, if they dare disagree with you on anything, comes across not as presidential but as pugilistic. It looks as if he will say anything and use any threat to get the end result that he wants. This is utilitarianism. Mm-hmm. When we talk, Matt, about the importance of worldview, when we talk about the importance of having a worldview that's based on principle rather than just pragmatism, this is the kind of place that it comes up when you see a president of the United States who says, you know what, I know I was supposed to have studied Marbury versus Madison. I know that I was supposed to have understood that the three branches of government are intended to have a set of tension between them, that they can to some extent undo what the others do, and that's what keeps anyone from garnering too great of a percentage of power. But it doesn't matter. All that matters is that he pushes through a radical piece of policy that, as you've pointed out, does something that has never been attempted before. It forces the American people not do something. It doesn't forbid the American people from doing something. It requires them to affirmatively purchase a product.
Well, it also, I think, betrays a clear misunderstanding on the part of the president, or I don't think it's a misunderstanding. I think he was just being dishonest and disingenuous on the concept of judicial activism. What judicial activism, he tried to turn it around and say conservatives are always railing against judicial activism. Well, yes, we are. We are saying, conservatives, that when a judge or a group of judges find a goal, some ideological goal that they wish to achieve, and manipulate the Constitution, ignore the Constitution, circumvent the clear enumerated restrictions placed on the federal government by the Constitution, when they try to get around all that to force some radical progressive change, which is clearly unconstitutional, that's judicial activism. When the court does what it is required to do and what it is duty-bound to do, which is to interpret the Constitution as it was intended by the framers of the Constitution, that's called the originalist interpretation of the Constitution, a judicial philosophy, strict constructionist, or originalist rather, that the court is supposed to apply through the prism of original intent. How did the founders envision the Constitution to be applied, and how is it supposed to restrict the federal government and keep the federal government from overreaching. That's exactly what the originalist judges on the court, and any judge that is not an originalist, is acting in a counter-constitutional manner. We have 4 justices currently sitting on the bench of the United States Supreme Court that buy into this living, breathing model of the Constitution, that it is whatever we say it is, whenever we say it is. So clearly this was a disingenuous portrayal of what is or what is not judicial activism on the part of this president. If the United States Supreme Court fails to overturn Obamacare, that would be judicial activism through an act of omission.
That's exactly right. Matt, I'm very slow to say that the President of the United States either didn't understand Marbury versus Madison or doesn't understand judicial activism. I think that he's brilliant, and I think that he knows very well what those terms mean. But as you point out, what this administration has become very adept at doing is literally calling good bad and bad good, calling black white and white black, calling things that are one way the 180-degree opposite of what they are. In this particular case, look, judicial activism is a very simple concept. It says that a judge is acting as a legislator. That's it.
Yeah.
Judges are there to judge, to compare what we do. The word justify, Matt, means to hold 2 things up side by side and see whether they match up. And one of them, the one that we set as the standard, if the other doesn't match up to it, you throw it out because it's not up to snuff. What we do in the United States is say that we, the people, drafted a master document saying, government, you can only do this much stuff. It's called the Constitution of the United States. Every law that we draft after that, every law is subject to the Constitution.
Right.
The judge is supposed to lay it right next to the Constitution and say, does it fit within the bounds of the Constitution or not? And if it's contrary to the Constitution, you have to throw it out. That's not judicial activism. Here's what it is. Here's what judicial activism is. It's when you switch hands with those documents and you say, you know what, the Constitution doesn't allow Obamacare to exist, or at least the individual mandate. So what I'm going to do is I'm going to search in the document and create, whether it be through a penumbra or through some other fiction, a place that I can find a way to shoehorn in language that does not exist in the Constitution. That's judicial activism, and that's what we've been standing against here.
Well, and I think one of the most obvious cases where the court did what you just described would have been Roe v. Wade,
in
pulling out of thin air this right to privacy, and saying that includes the right for a woman to have her unborn child slaughtered in the womb. Something clearly the framers, from an originalist viewpoint, would have scoffed at, recoiled at. Yet the court in Roe v. Wade invented this phantom right to abortion. Again, if the court here with Obamacare were to fail to overturn this clearly unconstitutional and individual mandate, that would be activism on their part. But what the president has done here is what we have become accustomed with this president, is he has politicized the judicial system. We saw it with him tasking Eric Holder in the Department of Justice with attacking pro-life advocates and abusing the federal courts in order to sue these individuals and try to intimidate them to interfere with their freedom of speech, their First Amendment religious liberties and free speech liberties. The president did that then. He has now developed a long track record of abusing the court system. Go back to his attacks during the State of the Union address a couple years ago, with the justices sitting right in front of him. The arrogance of this president to shake his finger at the court and presume to scold the United States Supreme Court for overturning another unconstitutional piece of legislation, McCain-Feingold in the Citizens United case. I have a feeling that this is backfiring. If Justice Kennedy was sitting on the fence here, I wonder if this might not help tip him one way or the other. Well, at Liberty Counsel, we stand up for the Constitution. We stand against true judicial activism, and we have been at the forefront in opposing Obamacare. It looks like in June, this bill may go down. We are hoping for it. We are praying for it. We encourage you to do the same. Go to lc.org to learn how you can become part of Liberty Counsel's mission.